calling docket number 21006-652, People versus Jennifer Crumbley, and docket number 21006-651, People versus James Crumbley. Please put appearances on the record, starting with the prosecuting attorney.
Good afternoon, Your Honor. Karen McDonald, appearing on behalf of the people of the state of Michigan. Good afternoon, Your Honor. Markeisha Washington, appearing on behalf of the people.
Good afternoon, Your Honor. I'm Shannon Smith on behalf of both Jennifer and James Crumbley.
Good afternoon, Your Honor. Marielle Lehman on behalf of Jennifer and James Crumbley. Today is the date and time set for a probable cause conference. Before we begin the probable cause conference, I just want to place on the record again and advise both defendants. Do you understand that you do have the right to retain your own individual counsel, and since you are co-defendants in this case, if a conflict exists and or arises, you may want to have your own independent counsel. Do you understand that, Ms. Crumbley? Do you understand that, Mr. Crumbley?
Yes, Your Honor.
Attorneys, can you advise the court and tell the court whether or not you believe a conflict exists as it relates to representation of these defendants at the same time?
Your Honor, we have gone over this extensively within our office and with our clients. At this time, there is not a conflict. We have addressed if a potential conflict, how that could arise. We don't anticipate that's going to happen. We have actually executed a written waiver of any potential conflict with our clients. We have gone over it over and over, repeatedly.
Okay, and you both understand it's your obligation to advise the court at any point in time during the course of these proceedings, including not just the preliminary examination, but up in the circuit court if it goes to that point of any conflict at the point that you recognize that one exists. Do you understand that?
We absolutely do. Thank you.
We do, Your Honor.
In knowing all that, I do. I'm sorry. Go ahead, Mom.
I said we do, Your Honor.
Ms. Crumbley, and knowing all that, do you still want to proceed today with these attorneys?
Yes, Your Honor.
Mr. Crumbley, do you want to still proceed today with these attorneys?
Yes, Your Honor.
Okay. All right, let's go ahead and as far as the probable cause conference is concerned, go ahead. Do you have any resolution on this case?
May I remove my mask to speak, Your Honor?
Go ahead.
I'm Karen McDonald on behalf of the people. Your Honor, as you are no doubt aware, on November 30th, 2021 in Oxford High School, 4 children were murdered, 6 children and 1 teacher were shot. Hundreds of others were terrorized. Approximately 300 officers responded to the area, including representatives from at least 26 agencies. At least 11 fire departments responded. The volume of discovery in this case is staggering. It includes a tremendous number of police reports, digital evidence, photographs, search warrant returns, ATF reports, FBI reports, witness statements, and recorded interviews. This case is unprecedented in Oakland County and perhaps the state. It is unlike any other case, and given that we submit that the typical protocols for discovery and the normal timeframes for a preliminary examination will not allow adequate time for the prosecution or the defense, for that matter, to adequately prepare. The parties signed and submitted a stipulated protective order regarding discovery for the court's signature. I will note for the record that the people in our position is that those sensitive digital and video material that indicate the actual shooting and injuries will not be released and can be viewed at our office, and defense counsel agrees. We've also put in place a protective order for all the rest of the evidence and documents so that it's not leaked on behalf of the victims in this case. Once counsel agreed to do that, we tendered approximately 500 pages of discovery, which I'm told they were in possession of late afternoon, yesterday. That was simply the first wave of data that we have, Your Honor. We've received another 40 gigabytes of data consisting of additional reports, recordings of witness interviews, surveillance videos, and witness statements, all of which must be reviewed and tendered. So we do not have all of the discovery. We approximate, we probably have a third of it. As you know, there are a lot of witnesses to interview, and that is ongoing. The Oakland County Sheriff's Office has been working around the clock to provide us with digital evidence obtained from electronic devices seized during this investigation. That evidence will be voluminous as well, and we don't have it in our possession. Our detective here, the officer in charge, can tell you he's worked around the clock, and most of his agency has as well as other agencies. As a result, we're asking this court to find good cause to waive the 21 days and adjourn the probable cause conference until after the new year to allow the parties to receive and review these statements. We anticipate being ready to present the preliminary exam in February, Your Honor. And lastly, as the court knows, these children's and family, these funerals have just recently concluded. The prosecutor's office has a lot of work to do with a lot of the victims and the families, and we do not think it's in their best interest or in the interest of justice to do that during the holiday season. There are several witnesses to prepare, and we want to make sure that we are prepared to go forward on the date and time set for the preliminary examination. We anticipate that it will be 15 to 20 witnesses and that it will take 3 to 5 days.
Anything on behalf of the defense attorneys relative to the request of number 1 for the request for the adjournment for the preliminary examination, as well as number 2, any do I place a stipulation on the record as it relates to the request of protective order?
Good afternoon, Your Honor. The defense does acknowledge receipt of the discovery that the prosecutor described. We are not objecting to the adjournment. In fact, we're joining in the request for the adjournment. And we did review and sign the protective order. We don't have any objection to the protective order.
So I do have a copy of a protective order that was provided to the court on December 13th at about 11:30 a.m. For each case, based upon the stipulations that were placed upon the record by both attorneys. I will go ahead and sign that protective order for both cases. As far as the request for the adjournment is concerned, can I have both the defense attorneys and the prosecutor approach the bench? Okay, after discussions with all counsel at the bench relative to the preliminary examination, which by the way is currently scheduled for the 22nd of December, there has been a request for an adjournment. Both parties are stipulating our agreement. I do need to place the waiver on the record. Mr. Crumbley, is he ready? Yes, Mr. Crumbley, do you understand that you do have a right to a preliminary examination within 14 to 21 days of the date of the arraignment, and that if I grant the request for the adjournment of the preliminary examination, you will not have it during that period of time? Do you understand that?
Yes, I do, Your
And
Honor.
are you willing to waive that right at this time?
Yes, I do, Your Honor.
And Ms. Crumbley, do you also understand that you do have a right to a preliminary examination within 14 to 21 days of the date of the arraignment, and that if I grant the request for the adjournment, you will not have your preliminary examination within that period of time? Do you understand that right?
Yes, sir.
And are you willing to waive that right?
Yes, sir.
The The court will go ahead and reset the preliminary examination for February 8th at 1:15. At this time, that's the only date I'm giving you. If it appears that we need additional days, then we'll deal with that on the 8th, based upon the availability of the court's calendar. Please make sure that you are all prepared to proceed to exam on that date and time with appropriate exhibits. If you want to have exhibits marked ahead of time, all you need to do is contact my court reporter, and that can you can have that accomplished. Okay, any argument on bond?
Your Honor, not at this time. However, the defense will likely be filing a motion regarding bond.
You're going to file a motion regarding bond?
Yes.
Okay. Well, file that motion, and then is that something you want the court to address on the 8th?
Your Honor, is there a possibility of getting a motion date before the 8th?
Are you doing one for sure?
Yes.
Are you definitely
Yeah,
filing a
we
motion?
just need to get a little bit more of the discovery, but yes.
When do you anticipate that you'll be filing that?
It depends when we get some discovery, hopefully within a week.
Okay, hang on a minute, I gotta check my calendar and see what I do. What's up here? To Jennifer's people. Do January 7th at 1:15. You file the motion, make sure you comply with the Michigan court rules in terms of filing the motion and providing the judge's copy if there's a response, and the prosecutor must also comply with the court rules in terms of filing the response. Okay, anything else?
No, thank you, Your Honor.
No. Okay, we're adjourned.